No contact means absolutely no contact. It does not matter if the victim reaches out to you 1,000 times by text message, Facebook, Instagram, every way possible. The victim does not have any no contact provisions in place. As the defendant accused of domestic assault, you have a bond condition that will require you to not have contact with the victim regardless if they reach out to you. So you respond one time out of 1,000 times they reach out to you, and you're the one that can go to jail, that can be held without a bond for violating your bond conditions if the victim decides to call the police or tell the prosecutor that you violated those conditions. Which leads to an important point in that the arraignment court date is usually going to be your first court date after you're released from jail after that 12-hour hold. Is there anything that can be done either at the arraignment or prior to the arraignment to lift that no contact or help the accused?
Potentially. So one thing we would have to do is we have to file a motion to amend the no contact order. Is the no contact order is not going away by itself at the arraignment just because you appear on that day and the person accusing you may show up that day. What we have to do is we have to file the motion to amend it to try to get you into court, potentially even before that court date, so that we can take it before a judge and try to get you back into the home and back with your loved ones.
And as far as bond conditions go, there's also additional bond conditions that may be in place. The law in 2024 changed, requiring a GPS monitor be placed on an accused in any case involving an aggravated domestic assault. Unfortunately, we've seen that also go into domestic assaults, not aggravated, where the magistrate may ask the alleged victim, whether or not they want that no contact in place, but also have a GPS with a cell phone app that can show them if the defendant is anywhere near them, to obviously protect the victim if they are truly in fear of the accused. And so another issue that we have been seeing in assault cases, specifically aggravated domestic assaults, is whether we can lift that GPS monitor, get it removed from the individual. Is that something that we're able to do as well?
Definitely. It's one that we're able to file a motion for it. We're able to discuss the issue with prosecutors because whenever they're going through, the magistrate should be setting the least restrictive condition possible, and more so should be setting the least required by law. Now, Brandon makes the point about it being required on an aggravated, but we're seeing it more and more with misdemeanor domestic assault throughout East Tennessee. So it's one that if you have been fitted with a GPS monitor, let us know. It's something that we can potentially file a motion to try to have that removed prior to the conclusion of your case.
Yeah. And you brought up an important point in that anytime bond is set, it's supposed to be the least restrictive possible. And so it's supposed to protect the victims, the accused, make sure that there are conditions that are going to ensure the safety of the community and the public. And so if we can show that there is no safety concern to the victim or the community at large, it makes us one step closer to lifting the GPS or lifting that no contact